Okay, we are live. It is 8 a.m. Good morning. Title and survey objections under the FARBAR contract is our topic today. Pretty excited about this. This is my world. My name is Sam Saad, and we are going to talk about the FARBAR contract. Last week, we talked about the NABOR contract title and survey objections. These are handled differently. And because I am an attorney today, we're going to start off with the disclaimer that I'm providing you advice, but not legal advice. And if you have any questions, you can ask them, but it does not create an attorney-client relationship unless we set one up. Just a little bit about me as a reminder. I've been an attorney for over 20 years. I am the scribe and past chair of the NABOR Legal Resources Committee, which drafts the NABOR contract. And I'm a member of the FARBAR Joint Drafting Committee, which drafts the FARBAR contracts. And my firm has been around since 2007, and we practice in all areas of real estate and business, estate planning, probate, business transactions, and looking forward to working with all of you throughout Southwest Florida and really the whole state of Florida. For all of your closing needs, we have a title company, Paradise Coast Title and Escrow, where we guarantee to have the lowest closing fee. We are always up to date on our crazy industry, and we have the top-notch security to protect your customers and their money. You can reach out to me anytime at 239-784-5556 with any questions or to send us an order. So talking about the FARBAR title and survey objections today, let's talk about a few initial thoughts, and then we're going to dig right into the contract like we always do. First of all, you are selling marketable title. That is what you are selling to your buyer. It's not fee simple title or clear title. It's a title that can be resold. It is marketable. And marketable is an interesting concept because I have a 1,000-page book called Marketable Title, and it concludes with marketable title is what two attorneys on the deal agree marketable title is. So there's not really a definition of marketable title. And we'll talk a little bit about the Florida Uniform Title Standards later, but that's just an attempt to get us to marketable title. So basically, there will be exceptions on the title. The last thought I'll leave you with before we dig into the contract is the survey is the second most important document in the transaction behind the deed. So please don't skip the survey, and we'll talk about that more as well. So let's talk about title evidence. So the title commitment is the document produced by the title company that tells you all of the things that are going to be on the title that have to be dealt with. That's the requirements, we call them. And it could be anything from provide the deed from the seller to the buyer and the money from the buyer to the seller, to we need a probate, or we need to clear the notice of commencement from a contractor off the title. So the closing agent delivers a title commitment to the buyer 5 days prior to closing on cash deals or 15 days prior to closing on finance deals. The seller has 5 days if they've got a prior policy, that is a policy from when they bought the property. And by the way, all these deadlines are typically from the effective date or the closing date, and I'll try to be specific. But the seller has 5 days from the effective date to get their old title policy to the closing agent, so the closing agent can use that as base title. Base title is where we start with for our title search. It's how far back we go. It's 30 years, then back to the most current deed. And we can talk about that in a totally different seminar because marketable title is its own animal. So the other thing is the contract talks about a municipal lien search. A lien search is different than a title search. Lien searches look for issues related to utilities, outstanding bond payments, local assessments, things like that. And that all goes along with the title search, but it's a different search and it has a different fee that the buyer or seller pays depending on who's picking for title in this contract. So the title commitment states the title defects the seller has to take care of before closing. And you have to remove all of the issues on title except for certain ones. And they are labeled in the contract A through F. And by the way, just so you know, I'm in standard A of the FARBAR contract is what I'm talking about today. I should have said that at the beginning. So for those of you that have the contract handy, it's standard A. And you take subject to. That they're these issues are in front of the buyer's title, and that's the land use planning, zoning, other restrictions, things that are on the plat, restrictions for oil and gas. These are things that the buyer takes subject to. If there are utility easements, provided they're not too wide, obviously you take subject to the taxes. The buyer will have to pay the taxes. And then any mortgages that the buyer assumes at closing, and make sure that you use the proper addendum for mortgage assumption if you do that. If there are any violations of these items, that's a title defect that the buyer can object to and the seller has to clear prior to closing. And the biggest thing is that there's nothing that would prevent the use of the property for residential purposes. And I'll take a moment for those of you that love the FARBAR as is contract. There's a line in the FARBAR and NABOR contracts that say the property is for use for residential purposes. So please don't use the FARBAR contract for commercial transactions. You immediately have a covenant violation, and we've got to get that fixed. There is a FARBAR provider, I should say Florida Realtors provides a commercial contract for your use that does not contain the residential purposes language. And I did tell you a moment ago that marketable title is determined according to the uniform title standards adopted by the Florida Bar. This is a 300-page manual. I have it in PDF. I'll share it with you if you want to see it. And it has examples and issues in it that determine that tell you whether a title is marketable. That is, whether you can issue a title insurance policy over the particular issue. And it could be that husband and wife convey to wife for life with a remainder to the children or something like that in the deed, and how you deal with that. That's what the marketable title standards are. So moving right along in our title examination process. So the buyer gets the title commitment from the title company, has 5 days after receipt to examine it and to notify the seller in writing of any defects that render title unmarketable. So the buyer takes a look at the title commitment delivered from the title company and says, these things affect my title, seller, fix them. And you can actually have an extension of closing for up to 5 days if the title commitment is late. So in my office, and I think any office that knows what they're doing, we do the title commitment immediately. We don't wait for the survey period, for the inspection period to be over. We just get the title commitment right away. If the deal falls apart, it doesn't cost our buyer anything. They don't pay for the title search until closing. But we get the title search in, we get it done, and we get it to the buyer so they can examine title. We get it to the seller so they can start working on the defects right away. I think that's super important that any closing agent that you use, get that title commitment done immediately, because there's a lot of information on there. It's the Bible of the closing, really. So the seller, once they receive that title commitment from the buyer, has 30 days, the cure period, to take reasonable, diligent efforts to remove title defects. Reasonable, diligent efforts to remove title defects. That's the standard. So if things have to be done to get the title into a marketable state and the seller delays and dawdles and doesn't do it, then the seller is going to be in breach of contract and you're going to have a problem. Whoops. If the buyer does not tell the seller that there are title defects that they've discovered, Then the buyer takes title as is as of the effective date, and that means they may be paying off notice of commencements for contractors. They may have code violations that will reduce to liens. There may even be an errant mortgage they got to deal with. So be very, very careful about that. If the seller cures the defects within the cure period and gives proof of the cure to the buyer, then we close on the closing date. If the closing date is passed, remember the seller gets that 30-day cure period, so you could go past the closing date on a quick close. You then close within 10 days after buyer receives the seller's notice that the title is ready to go. Does everybody understand that? You could have an extension of the closing date for the cure period. So let's get those title defects dealt with quickly so we don't have to go on extension. If for whatever reason the seller is unable to cure the defects within the cure period, the buyer has 5 days after the end of the expiration of the cure period to deliver written notice to the seller. Now, I want to make sure everybody hears me. At the end of the cure period, the buyer has 5 days to deliver written notice. This is a FARBAR contract. What do we know about FARBAR contracts? Time is of the essence for every deadline, and there are consequences for every deadline in the FARBAR contract. So when I get to the end of this, I want to make sure you understand that you could have a terminated contract if you don't give one of these notices. First of all, the buyer can extend the cure period up to 120 days, and the seller has to continue to try to remove the defects. This is called the extended cure period in the contract. And the seller needs to keep working. So if you had a probate, for example, the seller might need the extra days to get the order from the court. You would use the extended cure period. The buyer could elect to accept the title with the existing defects and close on the closing date, or within 10 days if the closing date is already passed, or the buyer can terminate this contract and walk away. Notice my next bullet point on the slide. If after reasonable diligent effort, the seller is unable to cure the defects and the buyer does not waive the defects, the contract shall terminate. So this contract kills itself if the buyer does not give the proper notice at the end of the cure period. So don't let your deal die if the seller is close to curing the title defect. You don't want your deal to automatically die. Maybe the seller will better deal you. Maybe you as the buyer needed this deal you needed a new house. So be very, very careful about all of that. Does everybody understand the survey, the title objections period now? It's get the title commitment as quickly as possible, but at least 5 days prior to closing to the seller. Seller clears the title, they have 30 days, the cure period. We close when title is clear or at the end of the cure period. Are there any questions about title examination before I switch over to the survey? Nobody raising their hand. Okay, let's talk about getting the survey. So the survey, at least 5 days prior to the closing date, the buyer may get the property surveyed. You've got to use a registered surveyor. You want to use a registered surveyor and get the survey to the buyer at least 5 days. If the seller has a prior survey, they have 5 days to get that to the buyer so the buyer can examine it and make survey objections or get their own survey. And I just can't emphasize enough how important this survey is. It is the only document that shows where your property is on the earth. You've got a deed that has a legal description. And I said this last time, if anybody knows where Block F, Lot 13 is in Lake Park subdivision, raise your hand. That's where I live. If you don't know where that is, you need an address. And even if you have an address, you're going to want to know, is the fence in the right place? Is the house in the right place? Is the lot what it's supposed to be? And all of this information comes from the survey. So please don't skip the survey. If the survey does disclose encroachments on the property that cross the setback lines, go on to the lands of others, violate any restrictions or government regulations, then the buyer delivers notice and a copy of the survey to the seller within 5 days of receipt of the survey, but not after closing. And then the seller's got to correct the objections. Um, if if the seller does have a survey and they can sign off that there's been no change to the survey, then the buyer can use the seller's prior survey for title. But I'm going to say it one more time. The buyer needs to get a survey. It's so important to understand the latest and greatest. I mean, with lasers versus old measuring tools. If your survey is more than 2 or 3 years old when you go to buy, I would just get a new one. It's so important. Um, Last thing we're going to talk about before I take questions is the seller represents that this is a representation in the contract that there is ingress and egress to the property that is insurable without exceptions. What does that mean? That the property is in fact accessible. Now, this is a big difference from the neighbor contract, which says that you have to have access from a public road. This just says access. So it could be a private road. And if it is a private road, then we need to examine the road documents or the easements involved. And we need to make sure that your buyer can get access to the property without exception. Otherwise, we have a title exception. So just to wrap it up, survey, title, most of this work is done by your closing agent, but as a realtor, you need to understand what's going on in the background because your customer is going to be asking you questions and they're going to be saying to you, what do I need a survey for? Why am I paying $500 for a survey? What's going on here? This closing is costing me all this money. What's a title commitment? What's a lien search? So understanding these things is super important. And now I will take questions. And we have a couple in the chat. Let's see here. Michael is asking, other than not being able to close, what are the ramifications to the seller if they do not try to cure title in the timeline? Yes, Michael, the buyer, you said, does the buyer get reimbursed for expenses? Michael, the seller would be in breach of contract for not exercising good faith and diligence, and the seller would be liable for their damages up to and including specific performance, damages, and return of the deposit. Skip, you were asking how best to handle issues with solar panels that have not been fully paid for but still have credits. Little outside the scope of this presentation, Skip, but solar panels and credits. Actually, I'm not super familiar with how the solar panel credits work, so I would have to research that and come back to you on that. Sherry is asking, as a listing agent, why would you want your seller to have liability if nothing has changed on the survey? They may not know. Sherry, that's an excellent point. Why would your seller ever sign a no change affidavit for a survey? One reason only, the contract says they agreed to do it. So if your seller moved a fence, changed an air conditioner pad, fixed the pool cage, did anything on the exterior of the property that affects the lines, they cannot sign an affidavit of no change. But they agree in the contract that they will sign an affidavit of no change if there are, in fact, no changes to their survey. Just saves the buyer $500. Deborah, we're talking about standard A, title standard A and B. And that's going to be on the regular FARBAR 7 contract. You're talking about pages 9 and 10. Oh, by the way, everyone, there's a new FARBAR contract. FARBAR contract 8 is going to be coming out soon with some major changes. So I'll just tease that. I'll be doing another big seminar on that here towards the end of the year. Once that contract is ready to go, we're working hard on that right now. Other questions? You can unmute yourself if you want to shout your questions out.
I just wanted to mention, hi Sam,
Hi,
that
Jessica.
when I explained to the buyers that they should strongly advise that they should get a survey done, not only because of what the title finds, but I explained that they can reuse this for when they need to put the fence or if they need to put a
That's right.
shed, like
Yep.
they're gonna get permits, it's just good to have. So I always mention that.
Yep. Yeah. Having a survey is it's a useful tool. It's as important as the deed. You need both of them. You really do. Other questions? Sherry, you unmuted yourself?
Yeah, what is I know you're saying it's number 8, but what is the form? What is the type of form that's being updated?
The FARBAR contracts.
Oh, the regular FARBAR.
The
Thank you.
regular and the as-is contracts are being updated. There's
Okay.
changes to FinCEN. There's changes to the way the dates are calculated, and one other change escapes me right now. But yes, there are three major changes coming to FARBAR. Other contracts or other questions? I mean, anybody? Jessica?
When we have a contract, um, and we represent the buyer
Yep.
or the seller, how soon should, let's say, a TC or the agent contact the title company to find out when the title commitment is back?
I would give them 3 to 4 days at most, maybe 5 days in season if we get busy.
3 to 4 business days. Okay. And then
Yeah,
so just
3 to 4
request it.
days, 5 days. Just say 5 days. If your title company has not delivered the title commitment within five business days of the effective date, then they're doing something wrong, unless there's a problem, and they should tell you about that.
Okay. And then once that's delivered, that's when we have the 30 days cure period.
Well, there's the title commitment goes to the buyer, who then has 5 days to give it to the seller, who then has 30 days to cure title in this contract. So it's 5/5/30.
Got it.
But really, what really happens is the title company emails everybody, buyer, seller, realtors, everybody, the title commitment, and that triggers the cure period. But the title company is already working on it. Like in my office, for example, at Paradise Coast, we get the title commitment, we immediately start curing title. And we get the title out to everybody. Then we're ordering what needs to be ordered in terms of lien searches and everything else at the beginning. We get all that back right away, and then we get it out to the parties right away. But we're just hustling and getting it done.
So when the title delivers it to buyer and seller and all parties, that's what triggers the 30 days?
Correct.
If the buyer it hasn't done it themselves to deliver it to
Right.
the listing
We
agent?
don't even wait for the buyer to say, I want to make an objection. We just deliver it. We have a standard email.
Okay. And what are the most common things that you find on those title commitments that need to be cured?
Oh, it's always the same. It's the association has a notice of commencement. We got to get a sufficient funds affidavit from the condo. We got to do a probate. We got to get the notice of termination from the contractor. We got to pay off the mortgage from the seller. Basic stuff. I mean, it's very rare. I have not seen a new issue in several years. They're all kind of the same now.
Okay.
David, you asked, how are surveys handled in an HOA where there are single family attached in condos? So Dave, if it's a single family, you're getting a survey. I just get a survey. Just do it. If it's a condo, you do not need a survey because you're insuring the airspace that is the condo, not the building. And if it's an attached single family, you have to look at the legal description. If it's set up in the condominium regime, no survey. If it's not a condominium, but it's like a detached villa type of thing where there's 2 or 3 together, we may or may not need a survey depending on what the documents say. That's a very good question, Dave.
So if we represent the buyer and they're purchasing a condo, there's no need to ask for the listing agent or seller to provide a survey?
You do not need a survey in a condo, no. Condos, no survey. Because you're insuring the airspace, remember? You're insuring the space that is the condominium unit itself. You're not insuring. So the survey only looks at the land around it. So if you got, like, for example, I had a deal, and this was 7 or 8 years ago, where the lender just demanded a survey of the condo building. Well, the condo building sat on a 6-acre complex with multiple buildings, and it was like $8,000 to do the survey. And we told the lender we're not doing it, and they passed it. They realized they had asked for the wrong thing. So, Brett, you had a question?
Yes, Sam. First, thanks for doing this. Really appreciate it.
Of course, love it.
Second is there a date that's set, and you may have said it, I just might have missed it, for the FARBAR and the FARBAR as is to be redone? Is there like an effective
Yes,
date?
it will be out by December 1st to comply with the new FinCEN rules. Yes.
Perfect. Okay, thank you.
Yeah, December 1st. It's interesting, just as an aside, this obviously isn't related to today's topic, but the FinCEN is being challenged by a title underwriter. Just came out today, so that is probably going to be delayed now. It'll be like the Corporate Transparency Act debacle of last year, where they just keep delaying and changing the rule and changing the rule and delaying, and nobody knows what's going on. But we'll deal with that as it comes up. Other questions on this or any other topic? All right, everybody. Thank you so much. Oh, Sherry, you have a question?
One quick one. I see on your card, Sam, that you also do, it says business. So do you also do the sale of businesses, or
We
what
do
does
the
that mean?
sale of businesses. We do a lot of business transactions in my office. We've done everything from boat condo buildings to hair salons to doctor's offices to all types of interesting. I did a lumber yard in Fort Myers. Lots of business transactions.
The
Yep.
real estate side of that, or both real estate, or if they sold a business without real estate?
Both. We do the whole thing. We do all the way from the letter of intent to the closing, real estate and non-real estate.
Wonderful. Thank you.
Yep. Mike, you had a question?
Yeah, Sam, my question was, for things like you mentioned before about the need for a survey and that too, do you have like a cheat sheet, that just explains, hey, here's the real need for a customer, for some of these different items, like a title policy, like the items that a customer challenges when you go in, when you're sitting down with the buyer? Is there a form that, or something like that you've put together in the past?
I've not put one together in the past. That's a great idea. Like what you need and why you need it type of thing.
Right. Because as you mentioned, and there's some great ideas today. People were sharing, hey, here's some other uses for surveys or, things like that. And, but I was just thinking for everyone's benefit, it is nice when you have something, in one place that just says, hey, you're going to need a survey because of this. Here's why you need the title policy. And just a quick, overview for them, because I just think it's a great reminder for the agents, as we're talking with the customers.
That's a great. I'll see if I can come up with a PDF. I'll put something together. Have my crack marketing staff. That's Jason.
Thank you.
Jason and I will come up with something. That's a great idea. Dave, you were asked about LOIs for commercial condos. I'm actually teaching the LOI class at NABOR in a couple of days, but I have an LOI slides that I can share if you don't make the class. All right, everybody, it's about 8:30. I like to keep these to 30 minutes. Oh, Jessica, you have one more?
Yeah, I have one more question.
Sure.
When you said the title policy is marketable, and I know that the buyer gets a discount if the title policy is less than 3 years,
Right.
how much of a discount do they get? How does
It starts at 50% and goes down from there depending on how old the policy is.
Okay, but it
So
can't be,
it's anywhere from 50 to 20% off.
okay, but it can't be more than 3 years.
But the seller's policy has to be less than 3 years old. That's right.
Okay.
And it has to be insured to the seller or their heirs.
Okay. Thank you.
Cool. All right, everybody. Thank you so much. I will catch up with you all on the next one. See you Thursday.